Hello, everyone. I'm Michael Clements, the Director for International Programs at the Business and Human Rights Resource Center. I'm joined today by our partners ActionAid International, Canadian Network on Corporate Accountability, the International Federation for Human Rights, Lawyers for Human Rights, LIDE, and the Zimbabwe Environmental Law Association, in welcoming all of you to the second webinar in our annual three-part series on the proposed binding treaty on business and human rights. Today's session promises to be a very rich discussion, as always. We're all aware that since negotiations on the binding treaty began in 2014, there have been fundamental shifts in the corporate accountability landscape and the wider social, political, and economic context. In the last decade, amongst many other things, we've all weathered a pandemic and its lasting effects on the global economy. The climate crisis has, of course, accelerated, and conflict has deepened in many parts of the world, often at the expense of the most vulnerable workers in global supply chains, as well as communities. But in the same period, we've also seen significant advances in corporate human rights due diligence regulation, robust demands from labor movements around the world, and continued efforts by human and environmental rights defenders to ensure rights protections in the face of growing corporate power. In this webinar, panelists will provide perspectives on what these changes and events should mean for the treaty and how they should inform the text that will be negotiated, now to be in December rather than October, as I'm sure we're all aware. I'm joined today by an excellent roster of speakers. The panel will be moderated by Madalena Netlia, Director of the Business, Human Rights and Environment Desk at FIDH, and who has worked in the field of business and human rights for over a decade and certainly been involved in the treaty process from the beginning. Before I hand over to Madalena, who will introduce the panelists and facilitate our discussion today, I have the privilege of introducing our keynote speaker, Laura Walters. Laura is a politician from the Netherlands, affiliated with the Labour Party. Since 2019, she served as an MEP and a member of the Progressive Alliance of Socialists and Democrats at the European Parliament. As the Vice Chair of Legal Affairs and Rapporteur on the Corporate Sustainability Due Diligence Directive, she's played a key role in making the EU CSDDD a reality, as I'm sure we'll speak about more today, and is now providing leadership in respect of the discussions on the treaty in the EU as well. She'll provide opening remarks for us, and then we'll depart for another engagement. Laura, the floor is yours.
Thank you very much. Thank you for having me today, and apologies in advance for not being able to stay after this keynote. I wish you all a very fruitful session, and I'm sad that I can't listen in to the rest of it. Thank you for the invitation to speak today in this lead up to the 10th round of negotiations for a UN treaty on business and human rights. 10 years in the making is something else than 4.5 years in the making, which was the amount of time we needed for European due diligence legislation. It's for the EU been a long slog, but vitally we got there in the end. There is now an EU piece of legislation on mandatory due diligence, and that makes me hopeful, even in the tough current situation on the UN treaty, about what's to come for that. At this time that we are speaking, we all know that the discussion in multilateral fora on responsible business conduct is stalling. And that's a problem because we also all know that corporate abuse has not stopped. We all know that as long as human rights defenders are being killed, as long as people are not making a living wage, as long as we have deforestation that goes into the products that we all buy, our work is not done. And I think there was a time not so long ago where we thought that maybe we were moving away from globalization somewhat. Certainly here in Brussels, you could hear people talk about nearshoring, you could hear skepticism on trade agreements. I think there was a sense that perhaps we were moving away from rather than in the direction of more globalization and therefore more connection between large multinationals and some of these abuses. I think that is not the case. And to take an example, the fast fashion industry. At the moment, it would seem that if anything, we are becoming more reliant on, for lack of a better word, more that in Europe we are using more supply chains in that fashion industry than we would have ever thought, I think, possible some years ago. And that's a problem, because in that sector that I'm just highlighting for a moment, but of course not the only sector where there's problems, I know that some of the brands that some years ago committed to things like using fewer synthetic fibers and moving away from that are actually using more of them now, leading to problems like microplastics, water pollution, landfill, etc. But in spite of some of these shocking examples of bad practice, such as in fast fashion, I do think that what is hopeful in all of this is that the responsibility of businesses and states to be protecting, respecting human rights, that is, in spite of these detrimental cycle, is no longer up for debate. And that, I think, is a political given. Is that enough? No, absolutely not. Clearly, we need to do more to guarantee accountability and justice at global level. And clearly, this treaty process needs new impetus. And looking at that through the prism of Brussels, for which you'll have to forgive me being a European lawmaker, I do see reasons for hope in that, not only in the adoption of the due diligence legislation, but elsewhere as well. You will no doubt be aware that this was not an easy negotiation. What started out as a logical step, something that at least in principle everyone agreed on, became increasingly controversial. It ended up being subject to multiple attacks from national governments, up to the point of prime ministers getting involved in this, and yet we got there. And that, for me, is the main thing. All of it could have left a bitter taste in the mouths of those who worked on this so hard. But I think what remains now is not that. It's the sense of achievement. And to me, that speaks to the acceptance that this is not going away. Human rights are now firmly on the agenda, even when the going gets this tough. You will know, of course, that the due diligence legislation is firmly embedded in the UNGPs. It sought to translate UNGPs into hard law. It's sought to do that as best as possible. Of course, is it a 100% match? No, that was not possible, both not technically speaking and not politically, but we've done our best to align. And why have we done that? Of course, we've done that because we know that many companies are already used to applying these UNGPs. And what we've wanted to do, of course, is to match the nature of the UNGPs with liability provisions that are not present in the UNGPs to fix the accountability issue that we all know exists with soft law. So in short, due diligence, of course, would not exist without the UNGPs, and it builds upon them. Due diligence, of course, also for the European due diligence framework now does not exist in a vacuum. And while it might be the largest law of its kind in terms of scope, this is 27 countries together, of course, making a law. It wasn't the first law of its kind. And the list of similar initiatives underway around the world is almost impossible to keep up with, even for a due diligence, responsible business conduct enthusiast such as myself. And I think that goes from Switzerland and Norway on our European doorstep to South Korea, Canada, New Zealand. The list goes on. And I think we will all agree that this is part of a broad trend towards unilateral action, or at least that this is something that we need to be extremely mindful of because of this scattered picture with legal gaps in it that might emerge. That is why it's so important that multilateral initiatives are taken forward, from trade policy to sustainability, and that is why we need to keep pushing at UN level. Now, I know that due diligence for some is seen as a unilateral instrument in itself. It's a European law for European companies based on company law provisions in our treaties that has effect far outside of Europe. And of course, that's something that some criticize. But I will stand by our right as Europe to legislate on our companies and our companies' behavior when they operate on the world stage. Naturally, of course, this has its limitations. I'm proud of the work that we did here, but those gaps at the moment, legally speaking, are significant, particularly in things like providing support to producing countries in the global south. And what we now need to consider is how the momentum here, perhaps in other places, but how that can give energy to multilateralism again. I think there, what we are after, of course, is scale and impact. And I think that the EU is uniquely positioned in this debate, but mostly that we have a unique responsibility. I think that one of my main frustrations with the EU sometimes is that we talk a great deal about our values, but we don't always follow through when it comes to putting our money where our mouth is on those values. And I think that means that now we have a responsibility, this law being across the line, to seek new impetus for the UN treaty and to try to push there as much as we can, despite our own difficult few months. Now, I know that our own history on due diligence, generally also, when it comes to those norms, is not perfect. But we do agree in the EU that our trading relationships ought to be influenced by our values, and that's something that I think we need to remind ourselves of time and time again, so that we take that responsibility. I think that means that we need to push. I don't think it means that we in the UN binding treaty negotiations need to come and say everybody needs to now copy the EU law. I do think it means that we have a responsibility to do what we can to unblock negotiations, to act as a mediator or perhaps a chief energy officer where we can, and take the role that we can in that process. I think the direction of travel towards mandatory human rights due diligence is clear and irreversible. And I say that having thought about it in a context that is changing at EU level and where human rights and legislation that enshrines it has come under attack. And I'm talking, for instance, about the report by Mario Draghi that takes particular issue with some of the legislation that we passed, due diligence, corporate reporting on sustainability, that is now framed as a burden. And yet, I think that the EU will recognize that at the moment the direction is that towards more sustainability, more transparency, towards enshrining human rights, and that undoing this will be an extremely tough feat for those who seek to attempt it. And I know that I will certainly stand in the way of those trying that. But to conclude here, I am firmly committed to doing what I can to reminding those in the EU involved in pushing for a binding treaty at UN level, multilateralism on all of these. And just as I say today that there would be no due diligence without the UNGPs, I hope that somewhere in the future we'll be able to say, the near future, if I can help it, but that there would have been no UN binding treaty without the CSDDD. Again, not because I think that we've done a perfect job here that just needs to be copied, but I think we have a responsibility in having managed to bring all these parties together in something that was not easy, to try to attempt that same thing and enshrine those norms and commitments at international level if we can. It's time to make that a reality, and I hope I work in Brussels together with efforts from around the world will unlock progress globally. Thank you very much.
Thank you very much, Lara, for this useful insight that also is particularly helpful to frame the discussion we're going to have later. So before introducing the panel and kick off the discussion, I just want to say one remark. You will be able to ask questions at the end of the presentations via the Q&A box. So please use the Q&A box for the questions so that it's easier for us to have a look at all the questions. And if possible, please have a clear and concise question and direct it to a specific speaker. So now let me introduce our four speakers who will continue the reflection that initiated already by Lara Wolters on some of the key elements of this shifting corporate accountability landscape that have been mentioned already before, and especially in the context of this year treaties negotiation. So we have as a first speaker Juliette Reynaud. She's coordinator at Friends of the Earth France. And she has worked in the extractive sector in different countries and has been participating in the UN treaty process since the first session in 2015. She was also at the heart of the battle for the French law on a duty of vigilance and is involved in the lawsuit against Total Energy about the impact of its activities linked to the East African crude oil pipeline. Then we have Todd Brogan, who is the Director of Campaigns and Organizing for the International Trade Union Confederation. The ITUC represents nearly 200 million workers in 168 countries. So it's the largest trade union organization in the world. And he has also been director of field mobilization for Amalgamated Transit Union. After that, we will have JB Garganera, who is the national coordinator of the Alliance to Stop Mining, a national campaign network in the Philippines, and who is actively engaged in Asian campaign for a legally binding instrument and the Philippines working on business and human rights. He's also part of the steering committee of the Asia-Pacific Gathering on Human Rights and Extractives and the International Steering Committee of Thematic Social Forum on Mining. And last but not least, we have Sikho Lutango, who is a program manager at the Rosa Luxemburg Stiftung Southern African Office and who's also a research associate at the University of Cambridge Institute for Sustainability Leadership. And her research focus is specifically on human rights and natural resource governance across the supply chain. So we can now start with our discussion. I will direct one question for each speaker, and I ask the speakers to please keep a time between 4 and 6 minutes for your answer so that we will have enough time for a Q&A at the end. I will turn now first to Juliette. So while Lara spoke specifically on the AUCSDDD, maybe you can help us having a broader reflection on other due diligence initiatives who are initiating in other countries, and especially on the elements that the treaty should take from them, but also if there are areas where the treaty needs to diverge or to be stronger to add something to them. Thanks, Juliette. The floor is yours.
Thank you. Hello, everyone. So it's a bit difficult to talk in only a few minutes. So I will mainly focus on the French law on duty of vigilance, which has been adopted in 2017, but with some insights on other national initiatives. So the French law was adopted in 2017, and then other laws like the German one has been adopted afterwards. And you have also laws that are being discussed, like in Brazil, with very interesting element that could be useful for the UN treaty. So first of all, in terms of what are the good points of the French law that we think should be important to have also in the treaty is, first of all, the question of the definition, the broad definition of the rights covered in terms of human rights and also environment, with a very different stand from what has been done in the EU directive. So there is no real definition taken in the French law, but just referring broadly to violation of human rights, fundamental freedoms, and safety and security of people and the environment. There is also a broad coverage of the supply chain. Here, what's interesting and also maybe a bit more difficult at UN level, but being national law, is that we don't need to have all the debate about trying to define what is a transnational corporation. We are defining the scope and the supply chain through the relationship between the parent or the parent company and the subsidiaries or subcontractors. But it means that the scope is defined by a threshold in terms of employee. This is on the contrary a weak point of the French law, which has a very high threshold of 5,000 employees in France, of 10,000 in the world. And so many companies from the garment sector or extractive sectors are not covered by the law. I want to focus also more, especially on the question of access to justice and liability mechanism, which is what we think is more important and needs to be strengthened, both at the national level and also in the UN Treaty. So in terms of other initiative, as I said, for instance, the German law is quite weak on that. It's not creating, it's not providing a new cause of action in civil law, linking the due diligence obligation to liability mechanism. So it's totally different in the French law, where the good point is that we have two legal mechanism. First one, which is a preventive action. So you can go to court even before a damage occurs if you consider that the company is not elaborating or implementing good prevention measures to prevent the risk of violation of human rights or the environment. And then you have the liability in terms of action for damage once a violation is caused. All these laws are only providing civil liability mechanism and not criminal. So in the treaty, it's good that we have this question on criminal liability. And what we think needs to be strengthened is the question, as I said, of access to justice. So, for instance, although there is like this liability mechanism in the French law, there is still a lot of obstacles for the affected people in terms of, for instance, the burden of the proof. We know that there is a lot of information that can be held by the company, or also, for instance, in countries where we work, like with partners in Uganda and Tanzania, really risk for people just to collect evidence or testimony on the ground. And also the cost of certain expertise. And so we think there should be really this reversal of the burden of the proof in terms also of presumption of control, the link, the relationship between the parent company and the subsidiaries, and also in terms of the presumption of fault, so that it would be the company that has to prove that he has done what is necessary to prevent the damage. In that sense, we have also good example from the Brazilian project, where there are some access to information measures. So it can be a help in terms of releasing, like weakening the burden of the proof. And also in terms of remediation, the Brazilian project is proposing an emergency fund for victims in case of a catastrophe, like the one that was caused by Vale, that would be paid by the companies. So it's not for if the company is whole liable, they should still have to pay in court, but it's more a fund for companies that are in risky sector, and that could be like for immediate relief of the victim. And maybe a last point, but very important, is the question of the focus on due diligence. We think it's more a weakness, both in the French law and also in the EU directive, because the issue is that here the fault of the company that can link to the recognition of its liability is the fact of not having elaborated or effectively implemented prevention measures. But what we see in court is that the debate is shifting from a debate on the measures, the standards. So what should look like the measures, what is the responsibility between the parent company and the subsidiary, etc., instead of really discussing of what is the violation that has occurred, what is the risk of violation, etc. And so we think that it's creating like a like a veil, an extra veil for the affected people, as they need to prove not only that there has been a violation or risk of violation, but also that the company has not complied with his obligation of prevention measures. And maybe just one more word, because I think I need to finish, is also the question of class action. We know that in many cases we can have thousands or tens of thousands of victims. And for instance, in France, we have just class action for very specific case, but not in the duty of vigilance law. And so if we take the case, for instance, of ECOP, we have more than 100,000 people that are affected, whose land is affected. But our case in courts is now with only 27 affected people, because it's too difficult to have a broader case. So it's also something that we think should be integrated in the UN treaty. Thank you.
Thank you so much, Juliette, also for keeping the time. So, and now I will turn to Todd, because it's true that in the treaty debate, the issues of labor rights and protection of workers has not always been spotlighted. So the question is, what role do you think the treaty could play in increasing protections for vulnerable workers in global supply chains? And what are the provisions that it's necessary to improve in order to ensure that protection?
Thank you very much. Yeah, I think it's worth noting that these negotiations have gone on for a long time. And when we speak to our trade union colleagues who are at the table, a lot of the sense is that many states just have not been serious about holding transnational corporations to account. And we at ITUC are trying to work to accelerate that process. That's why on Monday we released our first list of corporate underminers of democracy. And this is a list of emblematic companies who we think undermine democracy in myriad different ways, from union busting, which we view as an attack on democracy in the workplace, to climate destruction, which we view as an attack on democracy in our societies through destabilization, to massive clandestine lobbying and disinformation campaigns, and notably financing or platforming far-right anti-democratic political movements who, of course, promise further deregulation and dismantling of human rights law. And we released this list in part because of what's happening over the next few weeks and months, from the Summit of the Future to World Bank and IMF meetings to COP, and very importantly to the negotiations on the treaty. And we laid out not just the problem as we see it with corporate power and democracy, but also a series of reforms that we think can help turn the tide. And that includes, of course, a binding treaty. And so we launched a global petition for workers to that effect, which you can sign and see here in the chat. It is our hope that by aggregating research from across social movements and naming the worst actors, that we can both support grassroots and workplace campaigns against these companies, but also demonstrate to states that binding global treaties and regulations not only protect workers, but protect states themselves, especially those that view themselves as democratic, from a really perilous sort of oligarchic future. And so you can see our whole report. I'll drop another link in the chat. But to directly answer your question, we live in a world where transnational corporations, from the trade union view, are often more powerful than the states in which they operate. And that makes it incredibly easy for them to exploit and abuse and harm workers, both in home countries, but also and especially in supply chains with little consequence. So take Tesla, for example, which is a so-called leader in the transition away from fossil fuels, and also on our list of corporate underminers. In addition to being, of course, wildly anti-union, the Tesla supply chain relies on nickel mining companies in Indonesia that undermine established consultation standards with local Indonesian communities. Those suppliers are deforesting so rapidly that flooding and water pollution are threatening entire communities. And they rely on another corporation that is on our list, Glencore, to mine copper and cobalt in the Democratic Republic of the Congo, where child labor has allegedly been employed. And speaking of Glencore, I think many will be familiar with their horrendous record, but they were finally held to account by the US government for some globe-spanning corruption, which they admitted to on several continents, but very notably, they weren't held to account for their human rights abuses, and which is what the corruption made way for. And so that's where we see the real value of a global binding treaty like this. It's not the solution to all of our problems by any means, but we view it as a really important and increasingly urgent step to rein in some of this corporate power and to safeguard some measure of democratic control, application of human rights law. So to be effective, we're looking at 6 things, and I'll keep these brief. ITUC has 6 key elements that it's insisting on. One is broad scope. That means coverage of all internationally recognized human rights, including fundamental workers and trade union rights. Comprehensive coverage, by which we mean, and I think our first keynote touched on this, the inclusion of all business enterprises, regardless of size, sector, operational context, ownership, structure. The third is extraterritorial regulation, by which we mean that there's a duty to regulate corporations and provide victims of these human rights violations with access to justice in the home states of the corporations. The fourth is due diligence, which we've also heard about a bit on the call already, which is a mandate for businesses to adopt and apply human rights due diligence policies and procedures. The fifth is corporate accountability, by which we mean the reaffirmation of the applicability of human rights obligations to all corporate operations. And finally, and of course, international enforcement, a real strong international monitoring and enforcement mechanism so that this binding treaty can actually be put to use by the workers we've described. And so we think a strong binding treaty can be an important lever that organized workers can pull as they campaign to have their rights recognized or violations of their rights held to account. And of course, that requires large-scale worker organizing to use, but that's our job, and that's what we're working on.
Thank you so much, Todd, for this very comprehensive and interesting pictures, also for drawing the link between corruption and human rights violation, which is sometimes often overlooked. So I will turn now to JB to ask you if you can tell us a little bit more about what are the importance of having a provision concerning environmental protection in the treaty, also especially based on the work that you do in the Philippines and your experience on that. Thanks.
Thank you, Mada. It's very important among us environmental rights defenders that provisions on the environment are recognized, included, and of course, robustly supported for a legally binding instrument. And we see 3 basic reasons for that. Mostly aligned with what the previous speakers has said, but using from the environmental advocacy lens, corporations are committing environmental crimes, and they have to be held accountable to that. Second, while they are committing environmental crimes, the space for human rights defenders in general and environmental rights defenders in particular is shrinking. And the third reason why environmental provisions are very important is right now our international laws and multilateral agreements and even the United Nations are failing us. And we are part of that group that says maybe we need a shot in the arm, and hopefully a legally binding instrument would be one of many solutions that we need. But come to think of it, just the energy generated by discussing and pushing and advocating for an LBI, I think is by itself has value. Okay, let me go and elaborate on a few points. Number one, it has been said earlier, corporations are more powerful than our governments. And we have to understand it's our governments that are passing and supposed to be implementing environmental regulations. And that is not happening. Why? Because the motivation of corporations to profit is greater than the threat of environmental crisis and the potential of a planetary collapse. I mean, when they do their cost and benefit analysis, environmental and planetary stability is not there. And so and then you count that corporations have more economic, social, and intellectual powers than most of our governments. The technical expertise and even the financial and fiscal expertise are with the corporations, not with our governments. And so in many instances, corporations are actually financing and controlling political decisions and the priorities of our government. And in some instances, the beneficial owners of corporations that are impacting our environment are in fact our governments. I mean, in the Philippines, we can name the senators and members of our Congress who are chairing the Senate and House committees on environment and natural and even on climate. They're owners of mining companies and energy companies. So you have this imbalance right now. And if corporations are more powerful than our governments, then there has to be some way to hold them accountable. Now that's one leg that we are standing now. The other one, that's one bad leg we're standing now. The other bad leg we have is this shrinking space. And Global Witness just released their latest report a couple of weeks back. And the reports point to a continuing and worsening situation for human rights defenders, especially for environmental rights defenders. Of particular concern for us is that increasing risk, threats, and actual harm are being confronted by human rights defenders who are women and indigenous communities. And if we study deeper, why are the women and the indigenous peoples so much exposed and at risk? Because they are the ones who are most affected. The water and the well-being of the family is the main responsibility or obligation of the mother, and she feels she has to defend the water and the source of food and the well-being of the family. The indigenous communities are tied with their lands. The culture and the life are tied, and any destruction of the forest or the rivers is an affront not only to their livelihoods but to their very lives. And so they are there at the forefront, the women and the indigenous people. Now, just in here in the Philippines, according to that recent report by Global Witness, we remain as the most dangerous country in Asia for environmental defenders. Since 2000, well, in 2023 alone, 17 activists were killed. Go back since 2012, 460 activists have been killed across Asia. 64% of this occur in the Philippines. And many, if not all of these deaths, are linked to opposition against environmentally destructive industries such as mining, logging, and agribusiness. A final point why environmental provisions are critical for a legally binding instrument. At the end of the day, we can be frustrated how international laws and multilateral agreements are failing us, and of course failing communities. All of these agreements and international laws are not adequately implemented. They are taking too slow to be rolled out or simply not being funded. There has to be a way for us as affected communities to hold corporations accountable when their corporate activity result to environmental crisis, oil spills, pipeline explosions, gas leaks, and what Todd has meant, flash floods and landslides. Yes, they are brought by extreme weather events, but these extreme weather events would not have impacted so much if extractives and logging and deforestation did not happen in the uplands. If our mountains and forests were intact, the billions of money and lives would not be as worse as this we are confronting right now. And we are not even causing the displacement of indigenous and coastal communities because of land encroachment and reclamation projects. Finally, on this accountability, Todd, ITUC, I think, did a great work on that report. We have to continue this, and this has to be an important element on the legally binding instrument. We need to unmask who are the real beneficial owners of corporations, as they are the ones who are the primary responsible for destroying the environment, driving deforestation, and fueling this climate crisis. Amidst all the noise and the smoke, we have to use our critical analysis of how environmental crisis plays into the legally binding instrument. Let's disregard all the noise. And we are not decarbonizing, and we are not going into less extractive. At this point, we are in fact investing and opening up more fossil fuels, including more coal mining and coal power plants here in Asia. And with this mineral transition minerals and critical minerals, we expect more aggressive, wider, and more numerous mining to happen. At the end of the day, I think my last point would be the legally binding instrument must ensure that there are enough robust environmental provisions here that can adequately address both defending human rights defenders and also holding the corporations accountable. Thank you. Good evening.
Thank you so much, JB, for also this very alarming, I would say, but necessary picture that you gave us. And I will turn now to Siko to ask her if she can, using the examples from the African continent, talk about how changes in today's geopolitical context and the role of corporations should inform the treaty text, and particularly regarding the protection of victims from corporate abuses. Thank you, Siko.
Thank you, Madalena. So we have heard with the previous panelists that the Binding Treaty on Business and Human Rights is a process which is aimed at creating an international binding human rights instrument that goes beyond the United Nations Guiding Principles on Business and Human Rights, very long word, which is widely known as UNGPs. However, the process has been criticized for a lack of buy-in, especially from global North states that are also mostly home to transnational companies. These states include states like the UK, Germany, Japan, the US, and trade blocs like the EU. So this has created a massive divide among states on crucial issues. And basically, this has resulted in a stalling of the process. So these states that are against the treaty favor voluntarism over binding international regulations, especially given the non-implementation of the UNGPs by many states. And as such, within the UNGPs, as we have heard from Lara Walters, the CSDD was passed by the EU. The UNGPs, however, not been so well received by global South states, which are mostly host to transnational companies, precisely due to this voluntary nature. This is especially so it relates to the African states, where uptake has been minimal, with only a few states like Kenya implementing the UNGPs. What we're seeing now is that with the scramble for critical minerals and that drive, there has been geopolitical shifts, and acceptance of the process seems to be growing, at least. This was evident in the presence and constructive participation of not only previously reluctant states like the US, but also a growing number of African states, with newcomers participating for the first time, such as Nigeria. Nigeria, as one of Africa's oil-rich states and one of Africa's largest economies, has in the past been criticized by some states for its lack of participation in the process. With prevalent human and environmental impacts, such as the oil spill on Ogoni farmland that prompted the Shell versus Nigeria case in 2011, its participation is quite important in the process. Other African states participating for the first time included Kenya, Algeria, Senegal, Djibouti, the Democratic Republic of Congo, Sierra Leone, Angola, and Ghana. And returning states who have supported the process from the beginning included South Africa, Namibia, and Cameroon. So what we saw in the 9th session last year at the Human Rights Council is an unprecedented attendance and participation of African states in the process. And this reflects the changing geopolitical dynamics and what this can mean for Africa. African states are mostly located at the upstream level of supply chains, and this is where production occurs. And here, the human rights impacts in supply chains are mostly prevalent, as we've heard from the other previous speakers, in sectors such as the extractive sector. So seizing this geopolitical moment is extremely important for African states. So we've seen that the US and the EU have both enacted policies like the Inflation Reduction Act and the Critical Raw Materials Act to reduce dependency on Russian and Chinese supply chains due to increased risks. This has led to ambitious diversification targets, therefore seeking new cooperation partners or to strengthen the existing ones in what has come to be known as friendshoring, as also mentioned by Lara. So this is a major opportunity for African countries, especially as a bloc, to pivot away from export dependencies towards benefit sharing and industrialization. However, this must be accompanied by a push for stronger sustainability and human rights standards in supply chains to avoid the mistakes of the past. So with the required regulatory and governance changes on the continent, there are fears around divestment. So thus the growing strength of the African group in a process like the binding treaty process is a positive development within the current geopolitical context because it minimizes interstate investment competition. The African continent produces a significant share of the required deposits, including cobalt and lithium, as we've heard in the DRC, therefore rendering it an important player in the fight to uphold human rights standards. So just to say my final words, at the 9th session, for example, we saw that the African group was united on one particular issue, and that is scope, arguing that it should solely apply to transnational corporations. And I mean, the issue on scope is quite controversial with a lot of pros and cons. The group cited that it has concerns about how the treaty would impact the right to development if especially small to medium enterprises were to be subject to the same rules as transnational corporations. On the other hand, the EU supports a treaty that applies to all businesses. The CSDDD that was recently passed can be seen as a guide to what to expect when the EU eventually acquires a mandate, especially as it relates to scope. It could apply to all companies and with notable exceptions for size, number of employees or profits generated. However, in light of the geopolitical context, it is a good time for African countries to stand their ground on certain demands, despite their differences with key trade blocs like the EU. Another important issue that the African group should try and unite on and stand ground on relates to extraterritorial obligations, as mentioned by Todd, of states which both the UNGPs and the CSDDD have been criticized for lacking in clarification. Extraterritorial obligations are extremely important to ensure remedy across the supply chain for those impacted by human rights violations. Beyond that, the African group can also begin to pressurize potential cooperation partners to constructively participate in the negotiations like the EU. So while the EU had previously said that its participation hinges on the passing of the CSDDD, this year's negotiations are crucial to observe whether this commitment will actually come to fruition or not now that the CSDDD has been passed. So with that said, there are many opportunities to be gained from the current geopolitical context by African states, but there are also risks that can continue to perpetuate and to reinforce existing inequities, and African states should avoid this at all costs by leveraging the current geopolitical context. Thank you, Madalena.
Thank you, Siko. Thank you so much also for giving us this picture on what are the opportunities, like the political opportunities for the treaty. I just remind the audience that you can ask questions to the panelists through the Q&A box that you can see at the bottom of your screen. There is one question for Juliette, and it's about how the European Convention of Human Rights and the European Court of Human Rights could act into the implementation of mandatory the CSDDD. Juliette, do you want to briefly maybe give an answer to that?
Yeah, I'm not a specialist of the European Court of Human Rights, but a very good question. First of all, in terms of the European Convention of Human Rights, so this is a text, as many international texts, that we can refer to and use in litigation. So it's an important reference. And in terms of courts, it's what we call for in the UN treaty is the creation of an international court, or broadening of the mandate of existing international courts to be able to bring to court cases directly against TNCs and not against states, because these courts are often courts that you can brought your state to court, but you cannot bring directly the transnational corporation to court. So our demand would be to have a court that is competent to judge transnational corporation. We think it's very important because first of all, sometimes the national system is failing and there is a lack of access to justice at the national level, but also because as we speak of transnational activities, we also speak sometimes of damages and violations that are going across different countries. And so it seems to us very interesting to be able maybe to bring case to show the systemic violation that can come that can be caused by the activities of a specific transnational corporation or a specific project.
Thank you, Juliette. Thank you so much. There are other two questions. So one is for all the speakers. If you can express yourself on what extent the human rights are being presented by member states as indivisible. So it's about the scope, the material scope of the treaty. And the other one, I will just read them together and then I'll give you the floor. I know it's the same. Sorry, I have the two questions together. Yeah, so it's an interesting question because I think it's one of the key points. So who wants to maybe start answering that question?
I can go, Madalena.
Thanks, Siko. Go ahead.
I mean, what we see currently at the negotiations is that there are states who are looking to narrow an instrument from this broad spectrum treaty into a much narrower instrument in what has been referred to as a framework agreement. And this would be, for example, similar to the Convention on Tobacco, as you may know about this with the World Health Organization. So, I mean, the states that support a framework agreement to narrow these rights compared to a very, what they call a prescriptive and heavy and too broad treaty. I mean, these states are once again, mostly global north states who are home to transnational corporations. So this kind of proposal from the states, including the EU, including the US, and including states like Germany, with the engagement with African states, I foresee that it would be vehemently opposed. However, it seems as though there are some states that are willing to compromise, especially in Latin America. So it is possible that in the end, we do have a much narrowed down form of treaty, but this will receive quite a bit of a pushback from some global South states and especially African states.
Thanks, Teiko. JB, you also wanna take a shot?
Well, the way I understood the question was, are the states trying to limit or distinguish between rights that are being included as part of the scope of the treaty? So I think that's an important question. We have to be clear. I think the intent is and if we look at the draft, I think all the references on the Universal Declaration and all the other subsequent conventions are recognized. And so I think we can expect that at the minimum, the Universal Declaration and all other conventions that have been approved, adopted by the UN should be at the minimum included. And I think that's the source of discomfort when some rights, for example, declaration, the UNDRIP, the UN Declaration on the Rights of Indigenous Peoples, even if that is already widely accepted, I think there's still some pushback from several countries and make the distinction that there are no indigenous communities in their population. Now that introduces complications on the discussion and subsequent negotiations. I don't think any civil society or advocacy group that are pushing for the legally binding instrument would support any distinction or dividing up or reduction or splitting of any of the sectoral rights. I think there's universal acceptance. Human rights have to be recognized and included in any mode or form should the legally binding instrument move forward. It's a totally different negotiations and conversations with the states. But since the question is addressed to us, the speakers, I think it's safe to say that almost all of the civil society, affected communities, and the basic sectors that have unanimously supported the legally binding instrument, we want the full basket of rights to be recognized and fulfilled.
Thank you so much. I will maybe just now go to another question that I think it's interesting to respond to, and it's about the link between reporting and due diligence, and how and if this would be helpful to include in the treaty. And maybe we'll ask Juliette and Todd to respond to that.
Do you want to start, Todd? Sorry. Go ahead, as you haven't spoken.
No, please go ahead.
So the question about sorry.
The link between reporting and the due diligence.
And the due diligence. So for us, it's very important to distinguish what are due diligence obligation and reporting obligation, in terms that the reporting is mainly ex post, so after the action has been done, while the due diligence obligation are really in terms of prevention. Where that can be links, I would say, is the question of how much detail should be should the company have in terms of explaining its due diligence, its prevention measures. And it's, for instance, really a big debate right now in court in France, where we already have like a dozen cases. And so companies have to publish vigilance plan where they detail the prevention measures they take and how they identify risk. And there is a big battle, for instance, on the mapping of risk, as the companies don't want to publish too much. They don't publish much also about the measures that they plan to take or they are taking. And here it's also putting a heavier burden of the proof on the victim, because all this information about what is doing the company, of course, it's the information that the company is holding. So for us, it's very important that there are strong publication obligations that are linked to the due diligence, but once again, there must be very different from and separated from simple reporting obligation.
Thank you, Juliette. Todd, it's okay for you?
That's perfect. We agree.
Great. So I'm sorry we do not have much more time for the other questions, but I also want to thank the audience for having wrote questions that are very interesting. And I just want to thank all the panelists for their incredibly insightful and useful remarks and presentations. And saying that, just to conclude, I would like to thank you particularly for reminding us of the importance of these upcoming negotiations for ensuring the protection of communities, of workers, of the nature, and also because it provides an opportunity for states, for certain states to stand up. And what Lara said at the beginning is quite interesting, because even if the road might seem difficult, it is possible to do it, to achieve it. So I think this is a good reminder for us all that we can continue to fight for that, and we should continue to fight for that. I just want to remind that since the issue of scope came up quite a few times also today, that this issue will be particularly discussed in the next webinar, so on the 3rd of October. a panel of legal practitioners and civil society organizations will discuss the legal implications of what could be the different options for the scope in the treaty. Fernanda Oppenheim of the UN Working Group on Business and Human Rights will give a keynote speech, and Richard Miran from Late Day will moderate. So we look forward to see you there. And in meanwhile, I wish you everybody a good end of the day, start of the day, depending on where are you. Bye.
Thank you. Bye.
Bye.